Good day to you and welcome to another Paddocks Club video tutorial. Today I'm preparing to give a talk at the NAMA Indaba 2013 in Stellenbosch. That talk will be given tomorrow. But I thought I would share with you the first segment of that talk, which deals with the Sectional Title Schemes Management Act number 8 of 2011. So I'll take you very briefly through that. Just to give you an overview, that talk is going to go beyond this introduction and go on to an analysis of the terms of the Sectional Title Schemes Management Act, its regulations and its annexures at a very high level, not the detail, but the new ideas that are going to come through, that sort of thing. That's what I'll be dealing with. The whole process started with a decision by Cabinet in 2004 to transfer all housing-related legislation, including sectional title scheme management, from rural development and land reform to human settlements. And in that process, there were a number of sticking points. Two fundamental issues arose as between the two departments. First was whether the establishment of the body corporate should be a feature of the STSM Act or should remain in the STA. The second was whether body corporate decisions preliminary to various survey and registration acts should be in the STSM Act or should remain in the STA. Remember that survey and registration generally will all be left in the Sectional Titles Act. The question was whether the decisions body corporates take in order to enable those acts of survey or registration should be in the Sectional Title Schemes Management Act or in the Sectional Titles Act. These were unable to be negotiated, and ultimately the Chief State Law Advisor came in and mediated, and now both acts cater for the creation of the body corporate on the transfer of the first unit by a developer, and all management decisions are dealt with. The body corporate decisions that are preliminary to survey and registration acts are dealt with in the Sectional Title Schemes Management Act, not in the Sectional Titles Act, or at least they won't be once this Act comes into force. The Sectional Title Schemes Management Act went to Parliament with its existing content, that is the content from the Sectional Titles Act, rearranged for ease of reference, but with no content changes proposed by the Department of Human Settlements. But when it got to Parliament, the committee dealing with it, with the help of its researchers, made extensive changes. And they also had Parliament's legal advisors suggesting changes and the Chief State Law Advisor's office making changes. Ultimately, the time in Parliament and the move from one department to another cost quite a lot of time. And the Act was only promulgated and signed by the President, although not yet brought into operation, in 2011, the process having started in 2005. So what still has to be done before this Act becomes law? The first is, and only thing to be done, is the regulations. They have first to go to Parliament for consultation, and then they have to be promulgated. But before we can think of these things being brought into operation, we just need to recognise that there is a link between the Sectional Title Schemes Management Act and the Community Scheme Ombuds Service. Obviously, the one refers to the other and vice versa. So any hindrance in the bringing of the Community Scheme Ombuds Service into operation is a hindrance to the bringing of the Sectional Title Schemes Management Act into operation. So we basically have to wait until the Department of Human Settlements is ready to deploy the Community Scheme Ombuds Service, and then we will get the Sectional Title Schemes Management Act. I will take this further in further video tutorials, and I look forward to discussing any aspects which you find of interest in the discussion forum.